Okay, good day, ladies and gentlemen. This is IPF Live, and today we are live with Barrister Emmanuel Ukaegbu, who is going to walk us through some basic legal proceedings. Please say hello to the audience.
Good evening, ladies and gentlemen. Good day, everyone, wherever you are hooking up onto.
Okay, so thank you for joining us today. So we are going to go straight to the point. We know that in every country, such as Nigeria, there are things that are happening, security issues, criminal issues, legal issues, basic business issues that go around. And sometimes these things will involve the authorities, security agents in Nigeria, and also the court system, the legal proceedings, all what you have, and then defense attorneys. So we will use a specific, some general scenarios to educate our audience about some of these things. So if, for example, the authorities in Nigeria allege that somebody is attempting to commit a crime or is committing a crime, and then they go ahead and arrest the person. So what is the first step they need to do in order to prosecute such person?
Okay. Well, the first step in prosecution is for them to file charges against whoever they want to prosecute. And for them to be able to file charges, it is believed that they must have concluded with investigation. And from their investigation, they are satisfied that the person actually committed the crime, considering all the ingredients of the offense they are going to charge the person. That's the proper time to file a charge against an accused person.
Okay, so now how many days are they required by law to file any charge?
Well, when it comes to criminal offense, there is no time limit. So it is presumed that the law, once a crime is committed, the arms of the law can actually come against you anytime. There is no time limit. But the only issue is that once there is an arrest and you are in custody, they are now under duty to charge you within 24 hours or 48 hours, as the case might be. 24 hours is in a situation whereby you were arrested within an area that there is a court around it. So the Constitution envisage such a situation, you have to be charged within 24 hours. But if you are arrested and there is no court around, the Constitution also envisage a situation like that, whereby it is extended to 48 hours. So the security agencies, the police, or any other security agents, they don't have any authority to hold on to you beyond 24 hours or 48 hours without charging you before a court of competent jurisdiction.
Okay, so now, generally speaking, are the security agents, are they currently doing that, or are there situations where such things are not tenable?
Well, they are not actually, in all honesty, they are not doing that. They are not doing that.
So what would be the recourse of somebody? Because if the law says somebody should be charged within 48 hours and then the person is not charged, that means that person's right has already been violated. That's my understanding. So now,
yeah,
what would be the recourse of that particular person who is alleged to have committed a crime?
Well, it is a breach of the person's fundamental rights. You know, for you not to, for any security agent to hold the person in custody and not charge the person within 24 hours or 48 hours, as the case may be, is actually a breach of the fundamental right of the accused person. However, just like there are situations whereby the law, like the law on terrorism, it allows the security agents to approach a court and obtain a remand order to enable them conclude investigation whereby they've not been able to conclude the investigation when arrest was made. So they can actually approach a court. It is only the court that can say, go and ahead and hold this man in custody while you are carrying out your investigation. So in a situation whereby there is no such an order, though it is obtained by ex parte, anytime you hold somebody beyond the required time as allowed by the Constitution, you are in breach of the person's fundamental rights.
Okay.
So the person, whoever that his right is breached, now have a recourse under the law to still approach a court to demand for his immediate release.
Okay, now you mentioned things like security or a case like the alleged things regarding to terrorism or any other such security matter. So which level of court or type of court is the person supposed to be charged?
Now, there are, like when it comes to terrorism, you can only charge somebody on terrorism to the Federal High Court. And every other court, you know, the state courts, high court, you can charge them on the charge, depend on the crime. And there are also some crimes, maybe misdemeanor, simple offenses that can go at the magistrate court. But any case that is of capital offense will not go to magistrate court. It will definitely go to either the state high court or the federal high court, depending on the law that they're charging the accused person on.
Okay, so if it is not a crime that relates to terrorism and it's just some alleged security issues, does that same thing apply?
Yes, you can charge in a state high court.
Okay, and even if it's the federal agents that arrest the person.
Well, just like the Nigerian situation, we have Nigerian police. Actually, it's a federal control police, but they also police the whole of the states. And in every state, the police has its command. So the police can actually charge you on the state law that you breached, that you committed the crime. So it doesn't really matter whether it is from, you are calling it a federal police. No, police in Nigeria, police is police, Nigerian police. So they can charge you depending on the crime upon which they want to charge you. They will determine the court to go, whether it is federal high court or the state high court.
Okay, thank you. So when such issue arise, so obviously, is it advisable to consult a lawyer?
Good. Actually, it is very advisable to consult a lawyer. In fact, by the provisions of the Criminal Justice Act. That is the act that governs criminal trial in Nigeria presently, especially when it comes to federal offenses. Administration of Criminal Justice Act. By Section 17 of that act, you are entitled to a lawyer for you to even make a statement before a police. So for a police after a police has arrested you, you are entitled to a lawyer. It is of right. They have to tell you that you are entitled to a lawyer before you even make a statement before them. And in a situation where you don't have one, you have a right for them to provide you with one from the from all the, that is what's the name again? They have to provide you with one.
Some legal machineries they have in place, whatever that might be. Anyway, so if a lawyer appears, so what would be the first step of the lawyer in order to help the client?
The duty of the lawyer is to ensure that whatever thing that they are doing in accordance with the laws of the land. Just like most of the time, the security agencies apply force. They use crude means to obtain evidence from accused persons. But for the fact that you have a lawyer with you, they will not be able to do that. At least your lawyer will be able to see what is going on and make sure that any statement you are giving to them, it is a voluntary statement. You are not being coerced, you are not being forced, because the law allows you to keep quiet and not even to say anything when you are being arrested for any offense whatsoever. It is your right to keep quiet. And the police has a duty to inform you that you have the right to keep quiet until you have consulted a lawyer. So even if you don't have one, they will provide you the lawyers from the legal aid. In Nigeria, we have a legal aid council. So this legal aid council is being financed and sponsored by government to provide legal services in situations like this.
Okay, thank you. So now when a lawyer comes in, so the first thing probably they will determine will be whether the government authorities are abiding or following the law. So if in fact they discover that some rights has been violated, so what should they do? What do they typically do?
If who discovered that your right has been violated?
The alleged person's right has been violated. So if the lawyer of the alleged person discovers that some of the government agencies are not really abiding by the rules of the law, but by the tenets of the law, so what would the lawyer do in order to ensure that such thing happens?
Well, what the lawyer can do is that the lawyer will inform the investigating officers that they are overstepping their bounds, that they should do what the law requires them to do. And the lawyer is also not expected to interfere in the investigation. So he needs to strike a balance on how to call the police or the investigating officers to order. In situations where they refuse to be called to order, he can still, seek legal redress for the breach of the fundamental rights of the accused person in court.
Okay, so now once this accused person is charged to court, then the court system kicks in. Is that correct?
Hello?
I said once the accused person is charged to court, so the legal system kicks in, right?
Yes.
So now, what does the judge? What do they typically do in trying to is it prosecute or determine the case?
Okay, now the position of the judge is a position of an arbiter, and the judge is presumed to be an impartial arbiter. So for a criminal offense, the duty, the responsibility, the onus lies on the prosecutor or the prosecution to prove the case or the crime against the accused person. It is the duty of the prosecution to prove their case. It is the duty of the defense counsel to ensure that that the accused person is prosecuted in accordance with the law. Now, it is also the duty of the judge to ensure that for the judge to decide the case based on the evidence that is placed before him. Now, when it comes to criminal offenses, every crime has its ingredients. What makes up that crime? Either the forming of intention and actually committing the crime. There are offenses that requires, in fact, most of the offenses these two conditions must coexist for the offense to be complete. You must have formed the intention of committing a crime and actually taking steps to commit that crime. That's when offense is committed. Unlike where this does not apply to issues of negligence, So in forming that intention, that is what we call the mens rea. Why the actual taking step is what we call the actus reus. So when you are charged, it is the responsibility of the prosecution to make sure that there was an intention and to make sure and prove to the court that you actually took steps in committing that crime. So they are all issues of evidence. And when the prosecution is not able to, bring all this to the fore to prove it before the court, they have failed in their responsibility. And as a judge, the judge is not interested in emotions. The judge is only looking at, have you been able to prove the ingredients of these offenses? If there are 5 ingredients, the judge will look at these 5 ingredients. As long as they all exist in the proof of evidence and in actual evidence before the courts, that's when you can actually say that you have proved the offense. But if there are 5 ingredients, you're able to establish 3 or 4, you have failed in proving that offense. So, and the judge on his own will not say, they have tried, they have established 3 out of the 5 ingredients, or even established 4 or 4.5, that based on that, you will convict an accused person. It doesn't work that way. If there are 5 ingredients, the prosecution has a duty to prove all the whole 5 ingredients. And when he fails to do that, he has not been able to establish the offense. And the work of the defense counsel is to ensure that they are prosecuting every accused person in accordance with the law. What the law provides, they will make sure they are doing it the way the law asks you to do it. If they are to tender documents and they are required to tender original documents, you will ensure that it is the original document that is being tendered. And all that is more like making sure that the thing is done rightly. It is actually the work of the defense counsel, making sure that the prosecution is done rightly.
Okay. Now, sometimes the either the prosecutors, they accuse the defense attorneys of what they call stonewalling. So, what is that? Or or does it really exist, or does such thing exist?
You said what?
Sometimes the prosecutors, they publicly accuse defense attorneys of what I heard. They said is stonewalling or delaying the case. So does such thing exist?
Well,
or do they just make up things?
Well, actually, it is not. There are a lot of things that happen in the course of proceedings that can cause delay.
Okay.
And yes, these delays can happen in diverse ways. It can happen on the part of the prosecution. It can happen on the part of the defense. It can actually happen on the part of the judex, the judge. There are instances whereby you come to court and the court will not sit. So it is neither the prosecution nor the defense that caused it. And there are instances that you come to court, the prosecution will come without their witnesses. They will tell you stories that the witness is on a course, that they try to put course across, they couldn't produce their witnesses. And they will now say it is the defense counsel. And there are situations also, the defense counsel will not come to court for one reason or the other. So it is actually a compounded issue. But the truth is that any prosecuting counsel that is ready and willing to do his case cannot claim that the defendant counsel is delaying his matter. It is only when the prosecution is not up and doing that maybe the defense counsel can cash in into whatever thing he's not doing well to delay that matter. But
okay,
any counsel,
yeah, go ahead.
Yes, any counsel that knows exactly what he's doing, that is prepared to go on, it is very difficult and hardly for you to succeed in delaying his case.
Okay, now is there a typical timeline for some criminal offenses to be prosecuted? For example, I heard that political cases has to be completed within a certain time period. So now, regarding criminal cases, is there a timeline when a particular case that is brought to court must be prosecuted or concluded, so to speak?
Well, there is no timeline for prosecuting criminal cases. There is no timeline at all. However, the courts are enjoined to, or even the Act, the Administration of Criminal Justice Act, are enjoined to do the trial on day-to-day basis. But the unfortunate thing is that our court lists are so congested that it is practically impossible for us to have a day-to-day trial. But the law allows for day-to-day trial. It's just that
okay.
the system, does not allow for that day-to-day trial.
Okay, so now next question is, so once the case starts, so I have also read that in some cases the judge grants a client, an alleged offender, a bail, and then the government agent refuses to release the person. So what are possible reasons why that may happen?
Well, actually, that is the problem that we have found ourselves in this nation. We do not see the reason why a judge should grant anybody a bail and the security agencies will refuse to release the person upon fulfillment of that bail condition. In our law, every accused person is presumed innocent until proven guilty. So what that means is that the person enjoys the right of an innocent man, despite that there are charges that he is facing. And having to enjoy the right of innocent man, he should be allowed to move around, go about his business, but still come to face his trial. And presently, bail pending trial is of right to the accused person. It's of right. However, the accused person needs to enter into a bond or to ensure that he will always be available anytime his case is coming up. That is why when somebody is charged and the court grants the person bail pending trial, that bail will come with conditions. Those conditions are conditions that will ensure the attendance of the accused person all through his trial. So if you are presumed innocent until proven guilty and the court in his wisdom grants you bail and you have fulfilled that bail condition, if any security agent refuses the person to walk free after the fulfillment of that bail condition, is a contempt of court. And the court should frown at it. The society should frown at it. It can happen to, an obscure person today. You don't know whom will be the next. So we should all stand against such rascality. When a court of competent jurisdiction has given its order, granting somebody bail, and the person has fulfilled that bail condition, there should be no reason whatsoever for you as a security agent to keep on holding that person. When a court you brought the person to has actually given the person bail. So how do you explain that? You brought somebody to court for that court to decide the charge you brought against him. And the court in his wisdom has said, allow this man to be coming from home to face this trial, and you are refusing it. And you still want that court to hear you. That is not good at all. That is not fair, even to the court. You cannot be in the obedience of court order, and you will still be coming to the court to seek for the court's exercise of discretion.
Okay, so now, okay, thank you. So how about situations where somebody is granted bail and on the day of court, the person didn't come to court? So what is that called?
Now, when somebody is granted bail
and released,
and released,
actually released, yes.
Yes, and released, and the person did not come to court, there are bail conditions attached to that his bail. Let's assume that maybe he had a shorty. On that day that he did not come to court, his shorty has a duty to appear before that court to explain to the whereabouts of the accused person. There might be circumstances that would have denied the person from coming to court. We've had instances where the person is sick and bedridden. So it is the duty of the shorty to appear before the court to say, the person that I'm I have shortened his appearance and attendance before this court, is sick and cannot appear in today's proceeding. The court can believe the person, the court can decide to verify the assertion. And when the court verifies and finds that it is true, these are, circumstances that is beyond human control. The matter will be adjourned. Some people have been on their way to court and they got involved in an accident or one thing or the other, and that denied them from coming to court. But there should be an explanation. The only time there is an issue is when that there is no explanation. Nobody knows the whereabouts of the accused person. And the court is also under a duty to issue an arrest warrant or a bench warrant against the accused person, so that the person will be arrested wherever he is seen and brought back before the court.
Okay, thank you. Now, are there instances where a bail is met, the bail conditions are met, the person is released, and then the security agents rearrest the person?
Well, there are several instances like that. There are several instances like that. And in fact, that used to be their modus operandi, in situations whereby they don't want an accused person to walk free. After the court must have granted bail, and the person will meet his bail condition, on stepping out from court, the security agencies will arrest him and cook up maybe any other trumped up charges against the person. And now maybe charge the person in another court on another offense, different from the one that he was brought to court. We've had instances like that.
Okay,
and
so
that is completely wrong.
Okay, so how about some of the cases I've read that they say an accused person is brought to court, charged for one particular offense, and all of a sudden they say they are amending charges. So what is that? Is it allowed in the law? Or under what condition can that happen?
Yes, actually, it is allowed to amend charges. It is within the powers of the prosecution to amend its charges. And for you to amend the charge, you need to seek the leave of court. Then you amend. In the course of that amendment, you can now bring in new things that were not there before, correct the wrong things that were there. It is allowed. Amendment of charges is allowed, and it is something that you can do before judgment.
Okay, so next thing is the prosecutor allowed to share evidence to the defense before trial begins? How does that work?
Okay, now when it comes to prosecution of cases in the High Court, the prosecutor is under duty to share the evidence, because in filing charges, you file that charges with what we call proof of evidence. That is where you list out the documents that you are going to rely upon, all the whole investigation, everything that you are going to rely upon, it will be front-loaded. You will even list your witnesses so that nothing will come before the accused person or his defense counsel by surprise. So you have to front load all the whole documents you are going to rely upon. You front load your witnesses and all that.
Okay, so so once the trial starts, once the trial starts, so what are the steps that has to be taken, including the one by the prosecutor and the one by the defense team?
Well, the trial starts by, first of all, reading the charge against the accused person. The charge will be read for the accused person to plead. The accused person, before he will plead, he will also be asked whether he understands what was read to him. If he doesn't, then it will be explained to him. It is upon him understanding the charge that was brought against him that he will now be required to plead. He will be required to plead either guilty or not guilty. And there are instances whereby even if the accused person plead guilty, the court will still enter a plea of not guilty and still ask the prosecution to go ahead and prove his case.
Okay, so
now the prosecution, after taking plea on all the charges, that's now when the prosecution will now start bringing his witnesses to court. They will come and testify their, tell their story and maybe what they were able to gather in the course of investigation, the eyewitness account. It is at that point that the crime will be proved. They will tender all their documents, bring the whole evidence before the court. And after each witness testifies, the accused, the defense counsel is given an opportunity to cross-examine the witness. So it is now the responsibility of the defense counsel to make sure that he discredits the witness, or in the course of cross-examination, that he destroys the evidence of the prosecution. And what is the essence of that cross-examination? It is to test the veracity. It is to test the veracity of the account of the witness, the testimony of the witness. So when you put the testimony into test of cross-examination and such testimonies cannot stand, it then means the prosecution has failed in their duty, because none of us, neither the judge nor the defense counsel and even the prosecuting counsel, none of them were there when the crime was committed. So it is based on the account of the witness that has passed through a cross-examination, and in the court was able to believe the witness. That's when the witness may have discharged his duty.
Okay, so now are there instances where after the cross-examination, okay, let's start. After the cross-examination of the defense, so what's the next step that happens?
After cross-examination, the defense have, depending on the case or what you're able to do during the evidence in chief and the cross-examination, to either ask for no case submission if you realize that in the course of your cross-examining the witness that you're able to destroy the case or evidence of the prosecution. You can call for no case submission. You will address the court on how they've not been able to prove the charge. That's one step. You can go in and put in your defense. If you put in your defense, you bring your own witness that will tell his own story based on what the witness witnessed or saw when the alleged crime was being committed. And the prosecution also have a duty to cross-examine your own witness. It is after your defense that you can now you can address the court. Both parties will address the court. You can address orally, you can address by filing of a written address. Then the court will adjourn for judgment.
Okay, so who makes the final statement? Is it the prosecutor or the defense before the a judgment is made? Does it happen simultaneously?
It happens simultaneously. That is the address part. Both the prosecution and the defense, they all make their statement. However, if the accused person put up a defense and bring in witnesses that testify, he will make his own address first. He will make his statement first. Then the prosecution will now make his own address or make his statement after the defense must have finished. But where you did not put up evidence, it is the prosecution that will make first, because it is based on his evidence that you are relying. Then the accused person counsel will now make second.
Okay, now are there instances where judges are accused of being biased? And under what condition will such accusation arise?
Well, issue of bias is a very tricky issue, because why I say it is tricky is that what you feel that is issues of bias to, or what A feels that it is an issue of bias, B might not feel the same way. So we've had instances where either the accused person or the prosecution will accuse the judge of bias. They can accuse the judge of bias. Maybe the judge did not do the way they have anticipated. They will allege bias. And it will be proper that you have concrete instances that will be circumstantially, it will be so concluded that the judge is biased before you raise that issue. Because the judge is presumed to be impartial arbiter.
Okay, now are there instances where either the prosecutor or the defense will request that a judge be changed, and under what kind of situations that may arise before such things happen?
Yes, actually, when you, as a judge, when you are as a prosecuting counsel or defense counsel, or even the accused person, when you are convinced that the judge is biased and you can actually show it, you can request the court or the judge to recuse himself, so that another judge will take up the matter and do it. Because it will not be good for an accused person to feel that the judge that is deciding his fate is biased. So he has a right to complain. And if he's able to establish that, the judge will recuse himself. The judge will recuse himself.
Okay, so now are there instances whereby the judge, because when you are accusing, when somebody says when a prosecutor or a defense counsel ask the judge to recuse him or herself, so are there instances where they say no, that we are not doing it? And if they say no, is there a recourse? to make sure that that happens?
Well, there are instances. There are instances where, you know, either the prosecution or the accused person will allege bias. And the judge can actually say no, that I'm not biased. The only thing that can happen is for the person to appeal against it.
Okay, appeal at a higher court or where?
There are ways, or there are instances whereby you raise this issue of bias. Maybe you do a letter to the CJ, and when the CJ looks at that your application requesting for the assignment on issue of bias and feels that it is not founded, the CJ might not exercise its discretion to transfer the case to another judge. He will ask you to continue with the judge.
Okay.
That can actually take us back to maybe the issue of delay tactics that you have raised. There are some occasions whereby maybe the defense counsel will adopt such unethical method, because it's actually unethical, when there are not shown and clearly shown issues of bias against the judge, and you just raise it in order to delay the hearing of a suit, because such an issue can actually delay proceedings.
Okay, so after a judgment is read, both the prosecutor and the defense has all made their case, and then the judge decides, and somebody is found, let's say somebody is found guilty. So what is the typical appeal process if the person wants to go on with an appeal?
Yes, once judgment is delivered and the person is found guilty or the person is discharged, either the guilty person or the party that failed to prove the case can appeal against it, depending on the circumstance. Now, they can appeal, they have a period of 90 days within which to appeal. 90 days. So you appeal to the Court of Appeal, assuming it is a proceedings that took place in the High Court. You appeal to the Court of Appeal that takes appeal of that jurisdiction and raise those issues. If it is a case of conviction, the appeal will now be to set aside the conviction, and you will now give your grounds of appeal. It is in that grounds of appeal that you'll be able to, state clearly where the court erred, either erring in law or in facts or in mixed law and facts. So you'll be able to state where the court that gave the judgment, how he erred, and give particulars of those, errors. By the time you argue it at the Court of Appeal, the Court of Appeal will now look at it independently to see whether what you are saying in the grounds of your appeal are actually right or wrong. If they are right, they will set aside the judgment. If what you are saying is wrong, they will uphold the judgment.
And if and of course, if the judgment is upheld or set aside, either the prosecutor or the defense can still go to the Supreme Court.
Yes, you can still go to Supreme Court.
And the same procedure takes place, or is there a slight variation in what happens then?
No, is virtually the same procedure that will take place. But maybe what will change, the grounds of appeal might likely change, because you will now be appealing based on the second judgment, that is the judgment of the Court of Appeal, whether, based on their reasoning. So the likelihood that the grounds of appeal will change from what it was in the High Court is there.
Okay. So if somebody is filing appeal at the Supreme Court, so you are saying that the appeal now is based on the whatever judgment that was raised in the Court of Appeal, no longer what was done in the lower court, right?
Yes, but depending on the how you are or what you are appealing for, on the basis upon what you are appealing for, let's assume you are asking the court to set aside the judgment of the High Court. The Court of Appeal refused that request and uphold that judgment. So in the Supreme Court, you will now ask the court to set aside both the judgment of the Court of Appeal and that of this High Court. It has to follow, because it is the judgment of the Court of Appeal that is before the Supreme Court. Then you will now be asking the Supreme Court to do that which the Court of Appeal would have done, assuming they agreed with you.
All right. So one last question, please. So what are the instances where the defense may be accused of contempt of court? What instances?
Well, you can only be accused of contempt of court when you are in disobedience of court order, or when you have conducted yourself in such an improper manner that is unbecoming of a legal practitioner, and you conducted yourself in such a manner before the court. That's when you can be accused of contempt.
Now, are there instances where the judges threatens the lawyer, the defense counsel, or something? And under what condition?
In fact, the issue of contempt, some judges use it as a weapon against the lawyers. Some judges use it to intimidate lawyers. When you see some lawyers, they are doing their case the way they're supposed to do it, because they are not in agreement with the judge will begin to raise issue of contempt. And that is bad. A judge should not descend into the arena. He should allow the counsel and the parties to do their cases to the best of their ability. And most of the time, the judge should give the accused person every facility that he needs to defend himself. So when a judge is not doing that and he is descending into the arena, that's when you will see maybe altercation or any other form of disagreement going between the judge and the litigants. Is because the judge has descended into the arena. The judge should allow parties to do their case. The arena of litigation is a dirty arena, it's a murky water. So whoever that descends into it should be ready to get himself dirty. And when a judge descends into the arena and he got himself dirty, he will now begin to accuse the lawyers of contempt.
Okay, thank you. Thank you for being here with us and taking our question. I will appeal that you come back after a while for more issues and questions that our viewers may have regarding legal proceedings. Thank you, Barrister Emmanuel.
Thank you so much. Thank you for having me. Thank you, everyone, for listening to me.
Thank you. You're welcome. Have a nice day.
And you too.